Good morning, Ms. Cheek.
Good morning.
How are you today, ma'am?
I'm doing very well, and you?
I am wonderful. Which complex are you here for, ma'am?
Yes, I'm for, I think it's called Waverly or GNI, Harbor Club Apartments.
Okay, give me one moment.
Okay. Uh-oh. Okay, I think I got it right.
Ma'am, are you the listed tenant on the case or are you with somebody else?
I'm Carla Cheek Bryant.
Is it hyphenated on the notice from the court?
It is not. It's under Carla Bryant.
Thank you.
Yes.
Ms. Bryant, neither the attorney nor a representative from the complex are here as of yet. Sit tight when they get here. We'll get you matched up with them and get you into a breakout room to discuss the case with them, okay?
Yes.
Thank you.
Thank you.
Morning, Mary Ann.
Hi, Kenya, can you hear me?
Hi,
Hi, what is your name, please?
my name is Charity Brower.
And are you the defendant?
I am yes, the defendant.
And who's the plaintiff?
The Rawsonville
Rawsonville
Woods.
Woods.
Oh,
Ms.
okay.
Brower,
Yes,
you have your notice with you right there, ma'am?
I do.
Is your case number 224662 LT?
224662 LT. Yes, it is.
Your landlord dismissed the case. I signed the dismissal this morning. You'll get a copy in the mail within the next couple of days.
Okay.
Okay?
Sure. So does that leave me with 45 more days, or how's that work now?
The case is dismissed. There's no case that is pending with this court anymore.
Oh, okay. Thank you so much. I'm sorry. Thank you.
No, no worries, ma'am. You have a wonderful day, okay?
You too. Bye.
Thank you. Ms. Couch, good morning, ma'am.
Yes, hello, hi.
Hi, how are you?
I'm doing fine, and you?
I'm good. Is your name the name listed as the defendant in this case?
It's Bruce Paris.
Bruce Paris?
Yes,
224653. Okay, and what's your relationship to the file, ma'am?
that's my brother-in-law. He just
Where is
co-signed
he?
for me to stay there.
Are you expecting him to join us this morning?
No,
Rawsonville Woods has not checked in yet, ma'am. If you sit tight, when they get here, we'll get you matched up
okay,
with
that's
them.
fine. Okay, thank you.
You're welcome. Mary Ann, you took my control away some kind of way.
Oh, I didn't know I did that. Sorry, here. Oh,
That's okay. If you just make me co-host,
Yep.
please. Thank you.
you're welcome. Good morning, Miss Wright.
Good morning.
Hi, what case are you here for this morning?
It's at Rawsonville Woods, and I'm just a little confused because I didn't owe them, and they told me not to show up on the 19th, that would be cleared out. But I just got this notice in the mail yesterday about this
Ms. Wright?
morning.
Ms. Wright, is your case number 224660 LT?
Yes.
Your case has been dismissed. I signed the dismissal this morning. It'll be downstairs with the clerk's office to be mailed out.
All right. Thank you.
You're very welcome. Have a good day.
Thank you.
The attorneys aren't here yet. That's the only thing. As soon as I turn, I'm gonna say, as soon as I turn the light on, but I think that light's not working. Mary Ann,
Yes, ma'am.
224793, Romulus Towers versus Shipley. Mr. Shipley is here physically in the building, so his case will be the first case called when Mr. Rabbits or Mr. Novak arrives.
Okay.
Just so that the officers don't have to sit in here.
All right, thank you.
Thank you, ma'am. I gave her the note, so she knows.
Thank you. This is from the puppy. This is from my son's side door. The latch that holds on those things. It's kind of sharp. And I, it just ripped all the skin off. Yeah, I could have done without the Band-Aid, but it looks bad.
Yeah, I remember the puppy days.
Mhm.
She was never that big of a nipper with me. She got him good on his hand, like right here when she was young. She was more of a chewer of other stuff, boots and ottomans
Oh,
and
yeah.
whatnot.
If you don't catch her, she'll chew up your shoe, or he will. Come out in the park because they were having those. Did they show you that family picture?
Mm.
In order to finish the family pictures with the photographer, they had to tie him to a tree. So he ran around the tree and then it was full of hair bushes.
Oh, oh my gosh.
So this is what he did. After this trim, all his hair on his face, his legs, were all birds, and my daughter couldn't get them. So they had to take him to the crew.
Oh my gosh, poor baby.
He likes to use my arm to shoot.
Ms. Lange, Ms. Ross, Mr. Taylor, you're checked in right now. We're still waiting for the landlord to appear, their representative to appear. This court does start promptly at 9 o'clock. When your case is called, please be ready to put your appearance on. If you made an application for financial assistance, the court will ask you about that as well. But please be patient with us. We'll get to you as soon as we possibly can. Good morning, Mr. Kozinski. Sir, do you need to speak to Ms. Ross?
Oh, I'm sorry, Judge. Yes, if I could.
Okay.
Yes,
Ma'am, you're going to see an invitation to join the breakout room with your landlord. Please go there. It'll be room number 1, okay? Sir, she's in there waiting for you.
Okay.
Anything else going on?
Figured he'd need to be here this morning. He wasn't late for being here. I don't know if he's on Zoom.
Oh, well. So we're supposed to start at 9 o'clock. There's only one attorney here. And why is he not in the breakout room with this defendant? Yep,
Did he disconnect?
yeah. It's going to be Wednesday.
Somebody, if I was an attorney, I'd have to say my secretary sitting there doing
There are certain ones that do for that reason.
that.
just.
I'm gonna go and tell him
So we
that,
always, first we always,
Yeah, when you're ready, I'll bring him in.
I'm coming back out and just gonna get my robe and my notepad, but I'm ready to go. Just his attorney back here. Unless you want to sit here babysit with him, you can read it.
All right. Okay.
The one from that first door, she was the one that got away from her. No, only that you were doing.
I'm gonna jump in here.
okay.
Away we go.
You just have a seat there and just push your phone out.
Looks like we have 4 or 5 people in already.
So do we have to do other things, let me in?
You'll hear voices talking, but that's just another case, okay?
Are we ready on Moss?
Judge, this is Rick Kaczynski. My computer, we had power flicker, so I got kicked out. Can you put me back in the breakout
do,
room
sir.
with Miss Ross on the
Have a seat,
birch run?
please. Have a seat, please. Yes, Mr. Shipley, I have you checked in. I just have some other matters ahead of you. Yes, Mr. Kaczynski. Good morning, Mr. Morton.
Morning, Your Honor.
Mr. Morton, the court will make you. You're already a co-host, sir.
Yep,
Take rooms 3 and 4 as your meeting rooms this morning, okay?
3 and 4, understood.
If you see your tenants, grab them, move them in there. The court did receive your dismissals this morning. They're already signed.
Wonderful. I will speak to people and then come see Your Honor.
Thank you. Good morning, Ms. Dannon.
Good morning, Judge. How are you this morning?
I am super, ma'am. How are you?
I'm good.
There's only one case I see for Mr. Cox's office. That's Rita Bailey.
I show one other one, but
What's the other one? Oh,
It's,
you're
um,
right. Vanessa Miles.
that one actually is a dismissal so that you can pull that one off. But I also have Clifford Disney.
We have not received the dismissal for Miles as of yet.
Okay, I'll resend it.
Thank you. Well, we're a little short-staffed in the civil department this morning, so maybe it's here and it just hasn't come up yet.
I'll just make sure I send it again, just in case.
Thank you, Bradley, thank you. Good morning, everyone. It's this Wednesday, October 26, 2022. This is courtroom number 1. I am Judge Martin. This is a landlord-tenant docket. If your case does not involve a landlord-tenant matter, you are in the wrong courtroom. If you need assistance in getting where you are supposed to be, you may send a message to the court staff. Otherwise, we will get everyone checked in, matched up, get your cases called as soon as possible. Mr. Lamon, the court will make you a co-host and assign you to rooms 5 and 6. If you see your tenants, please feel free to grab them and move them into the room to discuss the matters with you.
Your Honor, I only have 5 cases. I'm not sure I need 2 breakout rooms.
Just as you can use one as your waiting room.
Okay,
Unless you just want them floating in the main session.
that's fine. That should work.
Good morning, Ms. Albu.
Good morning, Your Honor.
Ma'am, which cases are you here for?
4790 and 4403. One of the defendants is here. But I have
Ma'am,
not.
do you need to speak to?
Yes, to Ralph Greer.
And we're going to move you into number 10. Mr. Greer, please join the attorney to discuss the case. This is 224541 LT. This is Birch Run Cooperative versus Marquisa Ross. May I have your appearance, please?
Your Honor, Rick Kaczynski on behalf of Birch Run.
Ms. Ross, unmute yourself and state your name for the record, ma'am.
Marquisa Ross.
Thank you. Today is the day and time set for the second hearing in this matter. Sir, how are we proceeding?
Your Honor, Ms. Ross has been approved for ERAP, and I believe she has a number for the court.
Ma'am,
Yes.
what is that ERAP number, please?
It is 833. Hold on one second.
While she's going to do this, sir, what is your intention in this case?
And my client got a notice that she was approved. There is a balance due. I don't know if the court's putting stays on this case or not.
We can stay the matters. Notice of the stays will be mailed out to the parties. Ma'am, did you find that number?
Yes, ma'am. It is 833-742-1513.
Ma'am, what will happen next is that there will be a stay generated by the court and mailed to you. That just means that there's nothing else that will happen in this matter right now. Please submit all documents as required by the ERAP agency.
Okay.
You indicated, Mr. Kaczynski indicated that you've been approved for funding. There might be a possibility if the parties are able to execute a settlement agreement, a conditional dismissal, and submit that to the court for entry. If
We will do
within
that, Your
30
Honor.
days. Your landlord has not received that funding, they may make a request to the court to lift the stay in return for additional hearings in these matters, okay?
Yes, ma'am.
Anything else, sir?
No, nothing, Your Honor.
Anything else, Ms. Ross?
No,
Ma'am, we are all set. Have a good day.
you
Thank you,
too.
Judge. Have you too.
Thank you. Good morning, Mr. Herman.
Morning, Judge. How are you?
I'm wonderful. Good to see you, sir.
Likewise.
Are you here for Romulus Tower versus Shipley, sir?
I am, Judge.
Mr. Shipley is here in the courtroom. Mr. Shipley, come up to this podium for me, please, sir. Good morning. This is 224793LT. This is Romulus Tower versus Ricky Shipley. May I have your appearances, please?
Richard Herman on behalf of the plaintiff standing in for Lee Ravitz.
Your name, please, sir.
Ricky Shipley.
Thank you. Mr. Shipley, today is the day and time set for the second hearing in this matter. This is a non-payment of rent case. Have you made an application for financial assistance?
No, ma'am, I don't need financial assistance.
Okay, how are we proceeding this morning, Mr. Herman?
Judge, I'd like to take judgment by consent if possible. Mr. Shipley, you owe $2,403 in rent with $158 in costs, which totals $2,561, and that gets you all the way through October. Do you have that amount today?
No, but that's an incorrect amount, sir.
And why do you believe that to be the case?
Because I have a document from HUD that I received from HUD that was signed by Ms. Carr that the landlord had never seen. This is a U.S. Department of Housing and Urban Development recertification that shows my rent amount to be $226. The previous landlord, who is no longer there, tried to charge me $387, and that's absurd. She based that on a lie. She told me that my employer sent her over something that said my income this year was supposed to be $6,700. And in fact, last year it was only $335, and this year they said it was going to be $445.
Mr. Herman, is there someone here from Romulus Towers with the books and records?
I'm sorry, did somebody chime in there?
That's me, Mr.
Oh.
Herman, asking you, is there someone with you with the books and records from Romulus Towers?
Yes, I heard you. I heard you. I just heard somebody else in the background. Not as far as I know. Okay, not as far as I know, Judge. That was the same. My notes indicate from Mr. Ravitz that was the same discrepancy he claimed the last time at the first hearing, but I do not have anybody here at this point to speak to that, to the books and records.
Okay.
So I was wondering if perhaps, I mean, I hate to do this, but I don't have a choice. Mr. Ravitz is out of town and I don't have access to him. So I was
Mr. Herman, it's okay. We'll set a hearing date. I just don't have my calendars. Give me one moment, please.
Absolutely, Judge.
Give me one moment, Mr. Shipley.
Thank you.
While you're doing that, Judge, may I ask Mr. Shipley a question?
Okay, she stepped out.
You just stepped out of the courtroom.
Oh, okay, thank you.
Mr. Chipley, have you provided a copy of that document to your landlord?
I provided every copy that I needed to provide to my landlord in relationship to what document?
That which you just waived at the court that shows a different rental rate than what's listed on the complaint in this matter.
This was a document done by HUD. She has seen it. As a matter of fact, she wrote me an initial letter that says that this was what my rent is gonna be.
Okay, Mr. Shipley, we're not doing a hearing this morning because there is a dispute. The plaintiff is not entitled to entry of a judgment this morning. The attorney on the screen, Mr. Herman, is not the attorney of record. He's standing in, so there is no witness available to provide testimony in this matter this morning. The court will adjourn the court will adjourn this matter for a hearing. And I'm just looking at the dates. Mr. Herman, when is Mr. Rabbit's back returned?
1 week, Judge.
Okay. 1 week puts us at Halloween week.
We could do it after that, Judge.
I'm looking at. Is he back next Tuesday or is he available next Tuesday? I'm sorry, next Wednesday.
I honestly, I'm not sure. So if we could just adjourn it a few extra days from that, that'll give us more certainty.
14, 15, we already have stuff. Marianne, I'm looking at November 22nd.
Okay.
I'm just double checking that there's. November 22nd at 9 a.m.
Thank you, Judge.
That will be a live trial here in courtroom number 1.
Can I ask a question before you?
Absolutely, sir.
I would like to know, I have, this has been going on for several months, and it's a retaliatory eviction, and my only question today is can I put the money that I owe in rent in escrow today, so the court has, like 4 months or even 5 months, it would take me through November, because my July check, she rejected it, and, I haven't been able to pay rent ever since, but I do have the money, I don't want any judgments, and I would be happy to put as much money as you required in escrow today. I saved all my money because they wouldn't accept my rent.
Judge,
Mr. Herman,
I'm sorry. Go ahead.
absolutely.
So, Mr. Shipley, how much money have you been able to save up towards your loan?
I have, my rent, according to this document, is $226 a month. I can put up 4 months today at $226 a month, or even 5 months that would get me through the end of next month, which would be $1,130 is what I would be able to escrow today. And that would get me through the end of November in the event that it was found that my legal document is correct.
So, Judge, since Mr. Shipley is amenable to $1,130 in escrow, I would ask that the court order that. And I appreciate that, Mr. Shipley. And if I may, can I ask Mr. Shipley a question?
Absolutely, sir.
Mr. Shipley, you indicated that your employer says that your annual income is $6,000. What did you indicate that you feel it is?
Well, my annual income last year was $335.
I'm sorry, say.
This $335 was my income just from my employment. Up and above that, I get $885 a month from my Social Security. But she told me that the projected income for me this year was $6,000 $760. And when I asked her where she got that information from, she said, my employer. So I called
Okay.
Human Resources and they sent me over a slip that said, no, it's only $445.
Mr. Herman and Mr. Shipley, respectfully, this court has 40 other
Yep.
cases also scheduled at 9 o'clock. Mr. Shipley, the court usually only orders escrow prospectively, but in as much as you've agreed to an escrow order of $1,130, the court will prepare that. Schedule the live trial again for November 22nd at 9 a.m. back here in this courtroom. If there are documents that you want to share with the landlord that might help to resolve this matter before we return, don't take that. I would suggest and encourage you to get those copies of those over to them that might, again, assist in resolving this matter before that November 22nd date, okay?
Yes, ma'am. One other thing. My rent will be due again in a few days for the month of November. Can I come in the first of the month of November and add another $226 to?
I thought that the 11/30 covered November. Wasn't it what you said?
A month times 4 months would be, and then oh yeah, I'm sorry.
That's okay.
I'm sorry.
You're fine. The 11/30 order, so if you come back in, because the order's not going to be done instantaneously.
Okay.
Come back in a couple of days, there will be an escrow order on the file for you to deposit that 11/30 by next Friday, the 4th.
Okay, so I can't do that today. I can come in a few days.
Correct.
Would Monday?
That's fine. The order will be, I'll do it myself when I get off the bench. It's just, we're a little short in the civil department, so there's nobody who can do it right this second.
I
But
understand.
we'll get it done for you. And if you want to come back tomorrow, that's fine.
Thank you so very much. I really appreciate your help and thank you, sir.
Have a good
Judge-
day, Mr. Shipley.
Judge, Mr. Shipley, Judge, one more thing. I'm sorry. I know you're busy. I was just wondering if Mr. Shipley could give that document from HUD to the manager. I know he said he gave it to her once. If he could just do it one more time, I'd appreciate it, just to make sure that we have a copy of it.
That's fine. I have several copies and I have one right here. I'm happy to give one to anybody who wants one.
Thank you, Mr. Shipley.
Thank you, sir.
Have a good day,
Appreciate
sir.
it.
I'll see you in November.
Thank you.
Judge,
This
thanks.
is two-
Thank you.
Thank you, Mr. Herman. Take care.
Yes, yes.
This
you
is
too.
22447 8LT. This is Belleville Metals versus Vanessa Miles.
Good morning, Judge Carrie Zanin, P67390. Plaintiff moves for dismissal without prejudice on this one.
This matter was scheduled at 9 a.m. It's now 9:17 by the court's clock. The defendant has not appeared. Plaintiff's attorney has indicated that this case is being dismissed without prejudice. Upon receipt of the dismissal, Ms. Zan and the court will sign it. This is 224479 LT. This is Belleville Metals versus Clifford Disney. Clifford Disney. This matter was also scheduled at 9 o'clock. Ms. Zan and the court notes your appearance for the record. It's 9:17 by the court's clock. Clifford Disney, the defendant failed to appear at the first hearing in this matter. Based on that, court staff sent notice for the defendant to appear in person this morning. He has failed to appear. There's no one in the court's virtual waiting room. Mr. Disney is not sitting in this court's actual courtroom. Ms. Annan, based on this failure to appear, how would you like to proceed?
Plaintiff moves for default. Judge, can you pass me really quick? I'm so sorry. I know that I'm more comfortable asking you than the other one. Do you mind passing me? I'm asking for a default, but I am being called into a second court.
Go,
I'm so
just go. I'll call your two when you get back. Mr. Ms. Lang, have you spoken to Mr. Lamon?
Yes.
This is 224797 LT. This is Huron Estates versus Nicole Lang. May I have your appearances, please?
Good morning, Your Honor. For the record, Daniel Landman, P35797, on behalf of the plaintiff.
State your name for me, please, ma'am.
Nicole Lang.
Thank you. Today is the day and time set for the second hearing in this matter. Mr. Lamon, how are we proceeding this morning?
Your Honor, I did have a chance to speak with Ms. Lang. I don't believe that she disputed the amount that's claimed as due and owing. She did indicate that she has submitted a request for relief. And Ms. Lang, you'll have to assist me again. Which organization did you submit it through?
It's Wayne County Rental Assistance.
And she provided me with a confirmation number of N26615. I don't believe that that operates to stay any of these proceedings, as was the case with the SARA program. And I indicated to her that we would be requesting a judgment today, since there doesn't appear to be a triable issue, but that she should take that judgment to her caseworker, and hopefully that would expedite the issuance of a check on her behalf.
Mr. Lamb, what's the rent to retain possession, sir?
$2,216.48, Your Honor. Costs are $164.57. So we're requesting a possession judgment only in the amount of $2381.05.
Ms. Lang, you were able to hear Mr. Lamb just now?
Yes, ma'am.
Was that a correct amount of rent that he's indicated on the record, $2,216.48 in past due rent?
Yes, ma'am.
Ma'am, inasmuch as you do not dispute the amount of rent claimed due and owing in this matter, there remains no tribal issue. Plaintiff is entitled to entry of judgment in that amount. As Mr. Lamb indicated, the court would encourage you, once you receive a copy of the judgment, that you submit it to the agency that you've applied for financial assistance with, so that they know and see that your that there is a judgment in place, maybe that will expedite their processing of your paperwork or release of funds to your landlord, okay?
Okay.
Anything else, ma'am?
Not that I know of.
Anything else in this matter, Mr. Lamb?
No, Your Honor.
Thank you. Have a good day.
That's it?
That's it, ma'am.
Yeah,
Yes,
you're
ma'am.
free to leave the meeting, Ms. Lang.
All right. I don't understand what's going on now. What they're saying.
Your Honor, Ms. Angela Dudek is also here, and I've had a chance to speak with her.
This is 224806 LT. This is Huron Estates versus Angela Dudek. May I have your appearances, please?
Daniel Landman appearing on behalf of the plaintiff.
Ma'am, state your name for the record, please.
Angela Dudek.
Thank you. Today is the day and time set for the second hearing in this matter. Mr. Lamb, how are we proceeding?
Your Honor, once again, thank you for the opportunity for allowing me the opportunity to discuss this matter with Ms. Dudek. As was the case with Ms. Lang, I do not believe that there's a tribal issue. Ms. Dudek did not dispute the arrearage. The rent to retain is $2,055.56. Costs are $199.14 for a total of $2,254.70. As was the case with Ms. Lang, Ms. Dudek does have an ERAP application pending. That confirmation number is A30140. As was the case with Ms. Lang, I explained to Ms. Dudek that there is not any extra time allowed with the ERAP applications. It's not the SARA program. Ms. Dudek was encouraged to provide any judgment that was issued to her caseworker in the hopes that it would expedite the processing of her application. Your Honor, there is a second tenant defendant, Art Stillfried. He apparently is somewhere in the vicinity of Ms. Dudek, but he did not participate in our conversation. And if the court is inclined to enter a judgment, I would request that it be entered by default as to Mr. Stillfried, and then by hearing as to Ms. Dudek.
Ms. Dudek, you were able to hear Mr. Lamb indicate that there is rent to retain possession of $2,055.56.
Yeah,
Ma'am, is that an accurate amount?
yes,
Ma'am, inasmuch as you admit and acknowledge that the rent claim due and owing by the plaintiff is correct, there remains no tribal issue, and plaintiff is entitled to entry of judgment in that amount with court costs, as previously indicated. There is a
I would,
second defendant. I'm sorry, go ahead, ma'am.
I was told in the first hearing that if I had the ERAP number that I would get 45 days. And that I'd have to have it all caught up by a certain date, which I believe in my email was December 4th.
You were told that by whom, ma'am?
The lake, I think I talked to Lakeshore Legal Aid.
Ma'am, the way that the administrative order is written, it pertains only to a certain type of funding, these stays. This court had previously stayed ERAP applications, but there is no authority for that stay. So as Mr. Lamon has indicated, there will be a judgment entered in this matter. Upon receipt of the judgment, the court will suggest that you take it or submit it to the agency that you've made an application for financial assistance with. Maybe that would maybe expedite the release of funds to you.
Okay.
Okay.
Yeah.
Anything else, Ms. Dudek?
I'm confused as to what they're doing with Art. I mean, I'm like here for both of us.
You can't be there for both of you, ma'am, unless you're an attorney licensed by the state of Michigan. It will be a
Okay.
default judgment. It will be the same dollar amount. It will just be an indication that it was judgment entered by default.
Okay.
Okay.
Yep.
Good luck to you, Ms. Dudek. Have a good day. You may log off now.
Thank you.
Thank you. This is 224794 LT. This is Integrated Property Services versus Shamika Young.
Good morning, Your Honor. Dylan White, P 80755 for Integrated Property Services.
Morning, sir. Shamika Young.
Yes, ma'am.
Ma'am, have you spoken to Mr. White?
No, ma'am. No, ma'am.
Sir, do you want to go into a breakout room to discuss this matter with her?
Sure, Your Honor.
Could I also be added to that? I'm Elizabeth Castro here on behalf of the property managers for Integrated Property.
Sure, we'll get you moved into a breakout room.
Thanks, sorry.
This is 224479 LT. This is Belleville and Meadows versus Clifford Disney.
Again, Carrie Zandon, P67390. Thank you, Judge, for being so kind and passing for me.
No worries. Clifford Disney. Today is the day and time set for the second hearing in this matter. Mr. Disney failed to appear at the first hearing. He was supposed to appear in person this morning. Matter scheduled at 9 o'clock. It's now 9:27 by the court clock. Defendant having failed to appear, Ms. Zandon, how do you wish to proceed?
Plaintiff moves for default judgment at this time. Rent retained $2,225.27. Court cost of $164. So total rent retained $2,389.27. Asking for a writ issue date of November 7th of 2022. Possession only, Judge, and I will email a copy to the court this morning.
Thank you. Defendant having failed to appear, default judgment shall enter as prayed by the plaintiff. This is 224480 LT. This is Belleville and Meadows versus Rita Bailey.
Again, Carrie Zandon, P67. Sorry, Judge.
You're fine. Rita Bailey. Today is the day and time set for the second hearing in this matter. Defendant failed to appear at the first hearing. Based on that failure to appear, court staff would have mailed notice to Ms. Bailey to appear in person this morning. Ms. Bailey is neither in the courtroom, in the court's physical courtroom, in the court's virtual waiting room, or any of the court's virtual breakout rooms. Based on her failure to appear this morning, Ms. Zandon, how would you like to proceed?
Plaintiff moves for default judgment on this one as well, Your Honor. Rent retained $1,845.96. Cost to $164. Total rent retained $2,009.96. Asking for possession only. Writ issue date of November 7th of 2022. And I will email that over this morning as well.
Thank you. Based on the defendant's failure to appear as directed by this court, default judgment shall enter with the terms provided by the plaintiff. Anything else this morning, Ms. Zandon?
No, Your Honor. Thank you so much again. Have a wonderful day.
You too, ma'am. Thank you. This is 224644 LT. This is Stan Mikayura, sorry, sir, versus Earl Steele.
Good morning, Your Honor. I'm Stan McCura.
Mr. Mikura, have you heard from Mr. Steele this morning?
No, I haven't. It is a foreclosed property and the redemption period expired. I'm just looking for the possession.
Thank you, sir. This matter was scheduled for 9 o'clock this morning. It's now 9:30 by the court's clock. Defendant having failed to appear, plaintiff is entitled to entry of default judgment. Mr. McCure, if you would submit that judgment to the court, staff will send it upstairs. I'll sign it and the copy will go out to the mail, okay?
What do I have to submit, Your Honor?
I'm sorry?
What did you say I had to submit?
A judgment, sir. You have to submit a judgment that indicates that a default judgment has entered and the plaintiff will be entitled to entry of, the default judgment is entered and that the defendant has 10 days to vacate the property or that a writ may issue. You submit that at the court's civil department, sir.
All righty, thank you.
Thank you, sir. Have a good day. Mr. White, are we ready?
Judge, they went back into a
They
breakout.
went back, thank you. This is 224403 LT. This is Deutsche Bank versus Doris Jackson, Ralph Greer, excuse me, and all other occupants.
Your Honor, Morella Albu, P67035 for the plaintiff.
Good morning.
State your name for me, please.
Jermaine Taylor.
No. The case that the court just called was Jackson and Greer. Mr.
Yes, Your Honor.
Greer,
Mr. Greer, I spoke with Mr. Greer. He's on the call.
Ma'am.
Mr.
Ma'am.
Greer, please, oh,
Hello.
state your name and turn your video on for me, please.
Ralph Greer.
Today is the day and time set for the adjourned hearing in this matter. Ms. Alba, how are we proceeding?
Your Honor, yeah, I spoke with Mr. Greer. We have agreed on a consent judgment of possession with a vacate date of November the 14th. I will submit a judgment as to Mr. Greer as a consent and a default as to Doris Jackson and all other occupants. I have explained the 10-day right of appeal and 3-day right of rescission to Mr. Greer. And he has agreed to give me permission to sign his name on the judgment, which I will submit to the court today.
Mr. Greer, turn your video on, please, sir. Sir, do you swear or affirm?
Hold on, man. What did you ask me to do?
Turn your video on, please.
Okay, am I correct now?
Yeah, take your hat off, sir. This is court. Raise your right hand for me. Do you swear or affirm the testimony you give in this matter will be the truth, the whole truth, and nothing but the truth?
Yes.
Okay. Who is it that's here? Just wait, is that her in the front row? Yeah. Thank you. Mr. Greer, were you able to hear the comments made by the attorney just now?
Yes, I was.
And sir, you're wishing to sign a consent judgment indicating that you'll vacate the property on or before November 14, 2022.
Yes.
And sir, you're doing that freely and voluntarily.
Yes.
And ma'am, I'm sorry, sir, you've authorized the attorney to sign your name to that judgment.
Yes.
And sir, you understand that because the plaintiff is represented by an attorney and you're not represented, that this judgment will not be final and enforceable for 3 days.
Say that one more time.
You understand that because the plaintiff is represented by an attorney and you are not represented, the judgment will not be final and enforceable for 3 days.
Yes.
Thank you. And sir, you've authorized the attorney to sign your name to this judgment.
Yes.
Thank you. The court will enter the judgment against defendant number 2, Mr. Greer, by consent, and by default against defendant number 1, Jackson. Anything else in this matter, ma'am?
No, Your Honor.
Thank you. Have a good day.
Thank you. I
Is it
have one more case.
Bradley? Oh, wait one moment, ma'am.
Yeah, the other case is 4790.
Ma'am, no, ma'am. Sorry. Who is she then?
She was a roommate. She owns the trailer.
She owns the trailer? This is 224479 LT. This was Belleville Meadows versus Clifford Disney. This case was called at 9:27. Mr. Disney had not appeared. Ms. Ashley Amring has appeared, indicated that the defendant is deceased. Ma'am, the attorney has already left from Belleville Meadows. So a copy of the judgment is going to be mailed to the property, okay? Thank you. Mr. Bradley, do you have your case number? That's okay. Give me one moment. I wasn't trying to be rude to you. My apologies, but we have people in the physical courtroom that I'd like to get back out of so that the officers can close the court back up. Your first name, sir? Mr. Bradley, did you bring any paperwork with you this morning? That's okay. I'm just trying to look at the case number right now. And the computer's going so slow. Mr. Bradley, are you in Parkwood? You're supposed to be on Zoom right now. What I need you to do, sir, is go downstairs. I don't know if there's any Zoom room available for you, but I'm going to give you the case number. You're going to need to talk to the civil department to make sure that it isn't noted in the file that you have failed to appear this morning, okay? Thank you. And Officer Brooks is going to go downstairs with you and let them know that you've been sitting here with me. So it's not that you're late, but that you were sitting in the physical courtroom, okay? Thank you. Ms. Albu, your second case number, please.
4790 for DLJ Mortgage.
This is 224790 LT. This is DLJ Mortgage versus Matthew Holt and Michelle Holt. Ma'am, the court notes your appearance for the record. Today is the day and time set for the second hearing in this matter. Defendants failed to appear at the first hearing. Based on their failure to appear, court staff would have mailed notice to them to be in person this morning. There is no one else in the court's actual courtroom. There's no one in the court's virtual waiting room by the last name of Holt, and there is no one in the court's virtual breakout rooms by the name of Holt. Based on their failure to appear this morning, ma'am, how do you wish to proceed?
Your Honor, we are seeking a default judgment at this time with a vacate date of November the 7th.
Matter having been scheduled at 9 o'clock and being 9:39 by the court's clock, Default judgment shall enter in favor of plaintiff and against defendant with a writ date of November the 7th. Ma'am, you may submit that judgment to the court electronically. Anything else in this matter?
No, Your Honor, thank you. Have a good day.
You too, ma'am. Thank you. Mr. White, this is 224794 LT. This is Integrated Property versus Shamika Young. May I have your appearance, please?
Thank you, Your Honor. Once again, Dylan White, P80755 for Integrated Property Services.
Shamika Young.
Shamika Young.
Today is the day, ma'am, turn your video on. Today is the day and time set for the second hearing in this matter. Mr. White, how are we proceeding this morning?
Yes, Your Honor, I've had a chance to speak to the defendant. She agrees to damages, rent to retain being $1,500 plus $216.50 in court costs. She has indicated that she is going to receive ERAP, but plaintiff would still ask for a possession and money judgment in this case.
Sir, did you say cost of $216.50?
Yes, Your Honor.
Thank you. Ms. Brown, you were able to speak to the attorney this morning regarding this matter?
Yes, when I came last week, I'm sorry, can you hear me? Last week when I came in, I was put in a breakout room with the lawyer who made me do like this 45-minute thing just to tell me to complete this application because I wasn't familiar. And that all I had to do was bring you guys this confirmation number, and then I would be issued a 45-day stay until they completed the program because the ERAP takes 4 to 6 weeks. So that's what I came in with the knowledge of knowing, and now I'm learning that that's not true. So I don't know if I should be requesting to seek counsel or whatever the case, but that's what I was told to do today from the legal aid that you guys provided me last week.
Ma'am, is the person you talked to last week here with you this morning?
No, he said that he is George from, I have their
Mr. George
email.
from Lakeshore.
Yeah.
Ms. Brown,
And he
I'm
told
not
me,
sure
he
if you
said,
were-
I'm
I'm not
sorry.
sure if you were in this main session when the court indicated on the record that the court had previously been entering stays in ERAP matters, but there's been a clarification. Well, there have been objections by the attorneys that the administrative order does not specifically provide that ERAP would be subject to stay. If Mr. White's office has no objection, the court will enter the stay. The court has no mandate, no authority to enter a stay in this matter.
We would object, Your Honor. We would just ask that a possession and money judgment be entered today.
Ma'am, in as much as you have acknowledged that you owe this but have to rent, Mr. White has indicated that it's $1,500 in rent due and owing. And the question to you is that an accurate amount of rent due and owing?
Is it okay if I request an adjournment so I can seek counsel? Because I thought I came in thinking that I had already seek counsel and I was okay. I need to revisit my lawyer.
Your Honor, there's no tribal issue here today. We would just ask that the judgment be entered.
Mr. White, over your objection, the court will adjourn the matter. The defendant is requesting the opportunity to follow up and retain counsel. She's indicated on the record that she had previously spoken to Mr. George regarding this matter. This court does not have a next landlord-tenant date until November 22nd. That new date will be November 22nd at 9:30 a.m. That will be on Zoom back here with me in courtroom number 1. Is there anything else in this matter, Mr. White?
No, Your Honor, thank you.
Anything else, Ms. Brown?
No, ma'am.
I will see you back here on November 22nd. Thank you.
Very well, thank you.
Good morning, Your Honor. I'm sorry. My name is Diane Chapman. I'm not sure whether or not my case has been brought to your docket as of yet.
Ms. Chapman,
Yes.
I
And I
could not
was-
hear your question.
I wanted to find out had my name been called, and I was sent to a breakout room.
Ms.
with
Chapman,
one.
no, I haven't called your case as of yet. I see you on the
Okay, then.
docket, though.
Okay, thank you so much.
Thank you. Good morning, Mr. Lavasser.
Good morning, Your Honor.
How are you?
I'm doing well. Yourself?
I'm good. Sir, do you only have the 224791 LT Trade Winds Development versus Essence Made More?
That's the only one, Your Honor.
I am so sorry. This is, again, 224791 LT Trade Winds Development versus Essence Wade Moore.
Good morning, Your Honor. Randy Levasseur, P41712, appearing on behalf of the plaintiff.
Essence Wade Moore. Today is the day and time set for hearing on the second hearing in this matter. Mr. Lavasser, the case was scheduled at 9 o'clock. It is now 9:45 by the court clock. Defendant has failed to appear, sir. How do you wish to proceed?
Your Honor, we would move for entry of a default judgment of possession in favor of plaintiff that provides that if the defendant fails to vacate the property on or before November 7th, 2022, that the plaintiff may apply for an order of eviction.
Based on the defendant's failure to appear, default judgment shall enter as paid by plaintiff. Mr. Lavasser, if you would have your office submit that judgment electronically to the court for signature, it would be most appreciated, sir. Anything else in this matter?
Thank you, Your Honor. Is the court able to provide me with the preferred email address for that purpose?
It's civil at 34th District Court -mi.org.
Civil at 34 District Court mi.org
-mi.
-mi.org. Thank you very much. And
Correct.
just the court is spelled out, it sounds like.
Yes, sir.
Thank you very much, Your Honor.
Have a good day.
You as well.
Mr. Morton, I see you. Mr. Lamon has a fewer cases than you. Let me get the rest of his cases called.
That's great. If I may do one short thing, Your Honor. I'm trying to
Absolutely.
get two people to be able to move into a breakout room. So Diane Chapman and Devin Allen. My name's Attorney Ian Morton. My office represents your landlord. You should receive a request to go into a breakout room. Please accept that request as the court would like us to speak before we go back in front of the judge. So again, my name's Attorney Ian Morton. I'm talking to Diane Chapman and Devin Allen. Thank you, Your Honor.
And Mr. Morton, don't be long because I don't have that many other cases.
I like I said, those are the last two people I've been trying to get them to talk to me. So if not, we'll move forward.
Thank you. This is 224808 LT. This is Huron Estates versus Amber Blair Harbaugh and Robert Kirby.
Good morning again, Your Honor. For the record, Daniel Landman, P35797, on behalf of the plaintiff.
Amber Blair Harbaugh or Robert Kirby Jr. Today is the day and time set for the second hearing in this matter. Case was scheduled at 9 o'clock. It's now 9:48 a.m. By the court's clock, defendants having failed to appear. Mr. Lamon, how do you wish to proceed?
Your Honor, based on the defendant's non-appearance, the plaintiff would move for the entry of a default judgment for possession only. Based upon my client's books and records, the rent to retain is $2,109.84. Costs are $164.57. The total amount for the judgment then is $2274.41. We've requested an order of eviction issue after November 7th if that amount is not paid.
Thank you. Based on the defendant's failure to appear as directed by this court, plaintiff is entitled to entry of default judgment. Rent to retain $2,109.84, $164.57 in court costs for a total judgment of $2,274.41 with a writ date of November 7th. Anything else in this matter, Mr. Lamon?
No, Your Honor.
Thank you, sir.
Oh,
Was that it for you this morning?
Your Honor, I had what I thought were two other cases scheduled. I've been advised by Mary Ann that they are actually not up this morning, so I think that does complete our docket.
Thank you, Mr. Lamb, and have a good day.
You as well, Your Honor. Thank you.
Thank you, Your Honor. Mr. Abati,
Yes.
your case is scheduled at 10 o'clock. I have not seen the attorney for Ms. Ely as of yet, okay?
Okay. Thank you.
Thank you. Mr. Taylor? You've had a chance to speak to the plaintiff's attorney?
Yes.
Okay. As soon as he comes back out, I'll get your case called. You and Ms. Bryant, you've been here very patiently.
No problem.
what?
I sent you another invite, Mr. Allen.
Oh, hold on.
The person who's identified
Person
as
that just joined
Alex.
us.
Oh, sorry.
To the person that just joined us with the black scarf on, black hoodie, your name, please?
Curtis Metz.
Mr. Metz, I haven't seen Mr. Katz as of yet. Just if you sit tight, we'll get your case called when the attorney gets here.
Okay, thank you.
Thank you. You know what? I hate to do this. I need to get Mr. Morton back out here. Mr. Morton, the court asked you to return because Ms. Bryant and Mr. Taylor have been here for quite some time. I just want to get their cases called and get cleared up. We can get cleared up. This is 224682LT. This is GI&I versus Jermaine Taylor. Mr. Morton, the court notes your appearance for the record. Mr. Taylor, state your name for me, please, sir.
Jermaine Taylor.
Thank you. Today is the day and time set for the second hearing in this matter. Mr. Morton, how are we proceeding this morning?
Your Honor, Mr. Taylor provided an ERAP number, and I have that ERAP number for the court. That is J28860. So according to the court's current procedures, was that the matter would be put into the stay. I do have one procedural oral motion to make in regards to just a slight change to Mr. Taylor's name.
Yes,
And I'd move the court to amend his name. Currently it reads Jermanie, and the correction would be it's Jermanie. So I'd move by motion to just simply amend the first name to correct that slight admin error.
Mr. Taylor, is that the correct spelling of your name?
Correct.
The court makes an indication to file that the name will be changed to that. And Mr. Morton, if your office does not object to entry of the stay, the court will do that. Mr. Taylor, the next thing that you'll receive is a copy of the notice of the stay from the court. Please continue to submit the documents requested by the agency you've applied for ERAP assistance with. And if you are able to reach a resolution with Mr. Morton's office, I'm sure there'll be paperwork for you to sign and return, okay?
Okay.
Anything else, Mr. Taylor?
No, that'd be appreciated.
We're all set, sir. Have a good day.
You too.
Thank you. This is 224688 LT. This is GI&I versus Carla Bryant and Thomas Bryant. Mr. Morton, the court notes your appearance for the record. Ms. Bryant, state your name for the record, please.
Carla Cheek Bryant.
And Ms. Bryant, where is Thomas Bryant?
We are divorced. We divorced last year. He's been not in the residency for couple months.
Okay. Mr. Morton, how are we proceeding in this matter this morning?
Your Honor, Ms. Bryan applied for ERAP as well. The ERAP number provided was C29110.
Ms. Bryant, the court notes the ERAP number, and inasmuch as Mr. Morton's office does not object to entry of the stay, this case will be stayed. You'll get a notice from the court with that same information. Please continue to participate and submit the documents requested and respond to any requests for updates. If you and Mr. Morton's office are able to reach a resolution of this matter, please execute and return the paperwork to the court, okay?
Yes, is there a document that I need to sign to, I really don't know how it actually works as far as how the ERAP will be responding back to me?
What I'm suggesting is if you get approved and there's money that is coming, there
Okay.
might be a conditional dismissal or some other settlement document that Mr. Moore's office reaches out to you and asks you to sign.
Okay,
And if not, what'll happen is that this court doesn't have movement in the matter, we'll get it rescheduled for hearing. If plaintiff submits a request to lift the stay, we'll get the matter rescheduled, we'll proceed that way.
yes,
Anything else, Ms. Bryant?
no,
Thank you.
thank you.
Have a good day, ma'am. You're free to go. Mr. Morton, were you ready with Devin Allen?
Yes, Your Honor.
This is 224687 LT. This is GI&I versus Devin Allen and Danielle Allen. Mr. Morton, the court notes your appearance for the record. Devin Allen, state your name for the record, please.
Devin Allen.
And sir, where is Danielle Allen?
She's at home.
She's at home.
Yes.
Mr. Morton,
currently
how are we
out.
proceeding this morning?
Your Honor, Mr. Allen and I spoke. We've agreed to enter into a conditional dismissal. He's recently submitted a total payment of $2,100, which according to my records hasn't cleared yet, but that has been submitted. We would look to enter into a conditional dismissal with a, payment date of the 7th of November? Was it total due and owing before the $2,100 is rents retained of $2,399.23. Court costs of $189 for a total of $2,588.23. And again, we applied the $2,100 to that. The remaining balance would then be paid on or before November 7th. I did advise him of the 3-day time period that this agreement would not be final before, and he did give me permission to put his name on the agreement. Based on the fact that Ms. Danielle Allen is not present, we would simply seek that she would be entered into this agreement by default, as it would still be the statutory time period, and she'd actually be being provided additional legal protections than she would not be offered if we just did a default judgment.
Mr. Allen, you were able to hear everything Mr. Morton just placed on the record?
Yes.
And you understand that if the court adopts this conditional dismissal, you will have until November 7th to pay the balance due and owing after that payment that remains pending?
Yes.
And you've authorized Mr. Morton to sign your name to the conditional dismissal?
Yes.
And sir, you understand that because the plaintiff is represented by an attorney, you are not represented, that this conditional dismissal will not be final and enforceable for 3 days?
Yes.
The court has made appropriate notes in the file. Mr. Morton's office will submit that conditional dismissal. The court will sign it. A copy will come to you in the mail, sir. Anything else, Mr. Allen?
Well, that'll be all. Thank you.
Thank you so very much for your patience this morning, Mr. Allen. You're free to go. Have a great day.
You too.
Were you ready with Chapman?
Yes, I am, Your Honor.
This is 224671 LT. This is GI&I Harbor Club versus Diane Chapman. Mr. Morton, the court notes your appearance for the record. Ms. Chapman, turn on your video, unmute yourself and state your name for the record, ma'am.
Diane Chapman.
Today is the day and time for the adjourned hearing in this matter. Mr. Morton, how are we proceeding?
Your Honor, Ms. Chapman provided us an ERAP number. The ERAP number is as follows: D29082.
Ma'am, based on your application for the ERAP, Mr. Morton's office having no objection, the court will stay these proceedings. The next thing that you will receive is a copy of that stay from the court. It will indicate that if the plaintiff receives information that you are not eligible for financial assistance or you're rejected from the program, the plaintiff may file a request with the court to lift the stay and schedule this matter for additional hearings. Do you understand?
Yes, ma'am.
Ms. Chapman, do you have any questions in this matter?
No, ma'am.
Thank you, ma'am. We're all set. Thank you for your patience this morning. You have a wonderful day, okay?
You as well. Thanks so much. Bye-bye.
Thank you.
Bye.
Were you ready with Gibson?
Yes, I am, Your Honor.
This is 224649 LT. This is Rawsonville Woods versus Andrew Gibson. Mr. Morton, the court knows your appearance for the file. Andrew Gibson, please state your name for the record. Unmute yourself, sir.
Sorry about that. Andrew Gibson here.
Thank you, sir. Today is the day and time set for the second hearing in this matter. Mr. Morton, how are we proceeding this morning?
Your Honor, the parties have agreed to enter into a consent judgment after some adjustments that were made to the ledger. Was it the rents retained are $1,461.10. Court costs of $164 for a total of $1,625.10 with an applicable payment date / writ date of November 7th, 2022. Mr. Gibson did advise me that he does not live at the community. Was it in fact family members live there, but was it he understands his name's on there and he's working it out to be able to get the balance paid. Was it by that 7th date, Your Honor? I also advised him of the 3-day time period, and he gave me permission to put his name on the agreement, Your Honor.
Mr. Gibson, you're able to hear Mr. Morton clearly this morning?
Yes.
And sir, you agree that there's $1,461.10 in rent due and owing
Yep.
and $164 in court costs?
Yes.
And sir, you've authorized Mr. Morton to sign your name to a consent judgment with these terms.
Yes.
And you understand that because the apartment is represented by, the complex is represented by an attorney, you're not represented, that this judgment will not be final and enforceable for 3 days.
Right.
Sir, the court has noted the file. Mr. Morton's office will send that consent judgment electronically to the court. The court will sign it, and a copy will be mailed to you in the mail. Anything else, Mr. Gibson?
Nope, that'll be all. I appreciate
Thank you
it.
for your patience this morning, sir. You have a good day, okay?
You too.
Thank you. This is 224640 LT. This is Rawsonville Woods versus Vanessa Etherton. Mr. Morton, the court notes your appearance for the record. Ms. Etherton, please state your name for the record.
Vanessa Etherton.
Today's the day and time set for the second hearing in this matter. Mr. Morton, how are we proceeding this morning?
Your Honor, at this time, Ms. Etherton has provided the ERAP number, which is V30127. Based on that, the Sierra stay would be, the stay would be put in place for 45 days.
Ms. Etherton, you had the opportunity to speak to Mr. Morton this morning and he explained to you with the statement.
Yes.
And the next thing that'll happen is this file, in this file, that you'll receive a copy of that stay from the court. It will indicate that if your landlord has not received either payment in full or indication that you are not eligible for financial assistance within 45 days, they may make a request to the court to lift the stay and schedule this matter for additional hearings. Understood?
Yes.
Do you have any questions this morning?
No.
Good luck to you, Ms. Etherton. You're free to go. Have a good day.
Thank you. You too.
Thank you. This is 224664 LT. This is Rawsonville Woods versus Jordan Cole and Amy Shook.
Good morning, this is Jordan Cole here.
Mr. Morton, how are we proceeding in this matter? You're muted, Mr. Morton.
Sorry, Your Honor. Don't want my rustling in my chair to interfere when you're speaking to the parties. I was saying that Mr. Cole and I spoke. We've agreed to enter into a proposed consent judgment. Rents retained are $5,435.68. Court costs of $198, total of $5,633.68. The payment date would be November 9th, 2022. He advised me that Ms. Shook is still there. She would just be entered into this agreement by default, and he did give me permission to sign his name. And I also advised him of the 3-day time period, because he's not represented by counsel.
Mr. Cole, were you able to hear Mr. Morton clearly just now?
Yes, ma'am.
And do you agree that everything he said is true and accurate?
Yes, ma'am.
He explained to you that because the apartment complex is represented and you are not, that this judgment will not be final and enforceable for 3 days.
Yep.
And yes.
Yep. Yes.
And that because Ms. Shook failed to appear this morning, the judgment will be entered as a default against her.
Okay.
Okay. The court has noted the file will await receipt of the consent judgment from Mr. Morton's office. Do you have any questions this morning, Mr. Cole? Have a good day, sir. You're free to go.
All right, you too now.
Thank you. This is 224653 LT. This is Rawsonville Woods versus Bruce Paris.
Were they?
Kenya Couch. Did you speak to Ms. Couch?
Yes, I did. And I thought they were here still. Are they still?
She's still in the breakout. Let's
Okay.
get her. Marianne, could you move her out? This is 224631 LT. This is Rawsonville Woods versus Rosalina Alvarado. I have not seen Ms. Alvarado this morning. This case was scheduled for 9 o'clock. It's now 10:08 by the court's clock. Mr. Morton, based on Ms. Alvarado's failure to appear this morning, how do you wish to proceed?
Your Honor, based on Ms. Alvarado's failure to appear, rents retained are $2,208.02. Court costs of $164, for a total of $2,372.02. We'd ask a default judgment for possession only be entered.
Based on the defendant's failure to appear as directed by this court this morning, default judgment shall enter in favor of plaintiff and against defendant with rent to retain possession $2,208.02, $164 in court costs for a total judgment of $2,372.02. Plaintiff's office to submit that judgment for entry. This is 224651 LT. This is Rawsonville Woods versus Crystal Lee. This matter was scheduled at 9 o'clock. Notice was sent to the defendant to appear in person based on their failure to appear at the first hearing. Case was scheduled at 9 o'clock. It's now 10:09 by the court's clock. Mr. Morton, the defendant having failed to appear, how do you wish to proceed?
Your Honor, at this time, we'd ask a default judgment for possession be entered. Rents retained are $2,991.04. Court costs of $164, for a total of $3,155.04. This is a possession only action for non-payment of rent.
Thank you. Defendant having failed to appear as directed by this court, default judgment shall enter in favor of plaintiff and against defendant with rent to retain possession, $2,991.04, 164 in court costs for a total judgment of $3,155.04. This is 224653 LT. This is Rawsonville Woods versus Bruce Paris.
Yes,
State your name, ma'am.
Kenya Couch.
Thank you. Mr. Morton, you had the opportunity to speak to Ms. Couch this morning.
Yes, Ms. Couch provided a ERAP number K21900. And based on the court's procedures, the matter will be put into the state procedure based on the ERAP number that was provided.
Ms. Couch, Mr. Morton had the opportunity to explain to you with the statement this morning.
Yes,
Ma'am, next thing that'll happen in this case that you'll receive a copy of the state from the court. It'll indicate that within 45 days, unless your landlord has received payment in full or they received indication that you're not eligible for financial assistance, they may contact the court and ask for the stay to be lifted and additional hearings to be scheduled in this matter. Understood?
yes.
Do you have any questions this morning, ma'am?
No, I don't.
We're all set, ma'am. You're free to go.
Okay, thank you so much. Bye-bye.
Thank you. This is 224654 LT. This is Rawsonville Woods versus Jennifer Pieskey. Jennifer Pieskey, Mr. Morton, the court notes your appearance for the record. Today is the day and time set for the second hearing in this matter. Based on the defendant's failure to appear at the first hearing, the court sent notice for her to appear this morning in person. She's failed to appear, sir. How do you wish to proceed?
Your Honor, based on Ms. Pieskey's failure to appear, we'd ask a default judgment for possession be entered. Rents retained are $1,542.10. Court costs of $164 for a total of $1,706.10. And this is a non-payment of rent for possession only.
Based on the defendant's failure to appear as directed by this court, default judgment shall enter in favor of plaintiff and against defendant with rent to retain possession, $1,542.10, $164 in court costs for a total judgment of $1,706.10. Plaintiff's office to submit that judgment for entry. This is 224663 LT. This is Rawsonville Woods versus Valerie Brown and Damon Bryant Jr. Today is the day and time set for the second hearing in this matter. Defendants having failed to appear at the first hearing, notice was sent for the defendants to appear in person this morning. Mr. Morton, the court notes your appearance for the record indicates that neither defendant has appeared or is responding to the court call this morning. Based on their failure to appear, sir, how do you wish to proceed?
Your Honor, based on the defendant's failure to appear, we would ask a default judgment for possession be entered. Rents retained are $1,536.56. Court costs of $198 for a total of $1,734.56. This is a non-payment of rent for possession only, Your Honor.
Thank you. Based on the defendant's failure to appear as directed by this court, default judgment shall enter as prayed by plaintiff rent to retain of $1,536.56, $198 in court costs for a total judgment of $1,734.56. Plaintiff's office to submit that judgment for entry. This is 224669 LT. This is GI&I Harbor Club versus Sherry Anderson. Today is the day and time set for the adjourned hearing in this matter. The defendant failed to appear at the original hearing. Court staff sent notice to Ms. Anderson to appear in person this morning. There is
Rebecca Anderson is a paralegal with my office, Your Honor. So
I'm with you. It took me half a second, sir. Mr. Morton, the court notes your appearance for the record. Based on Ms. Anderson's failure to appear this morning, sir, how do you wish to proceed?
Your Honor, based on Ms. Sherry Anderson's failure to appear, we would ask a default judgment for possession be entered. Rents retained are $2,600. Court costs of $167 for a total of $2,767.00. Again, this is a non-payment of rent for possession only action, Your Honor.
Based on the defendant's failure to appear as directed by this court, default judgment shall enter in favor of plaintiff and against defendant with rent to retain of $2,600 is $167 in court costs for a total judgment of $2,767. Plaintiff's office to submit that judgment for entry. The next case is 224676 LT. This is GI&I Harbor Club versus Christopher Hughes. This matter was scheduled at 9 o'clock. It is now 10:14 by the court's clock. Based on the defendant's failure to appear, Mr. Morton, how do you wish to proceed?
Your Honor, we would move forward to seek a default judgment for possession. Mr. Hughes has been making some recent payments, including a $1,000 payment, which brought the balance down to a lower amount. Rents retained now remain at $132, core costs of $167, for a total of $299. So there's been significant payments made on the account.
Mr. Morton, the court will grant the plaintiff's request for entry of default judgment with rent to retain possession of $132 if $167 in court costs for total judgment $299. The court will not enter a writ without a hearing in this matter based on the balance of rent due and owing.
Understood.
Thank you. This is 224680 LT. This is GI&I Harbor Club versus Marquise Salisbury. Today is the day and time set for the second hearing in this matter. Defendant failed to appear at the first hearing. Based on that, court staff would have mailed notice for them to appear in person. They have failed to appear this morning. Case was scheduled at 9 o'clock. It is now 10:15 by the court's clock. Based on the defendant's failure to appear, how do you wish to proceed, Mr. Morton?
Your Honor, based on the defendant's failure to appear, we would ask a default judgment for possession be entered. Rents retained are $2,545. Court costs of $167 for a total of $2,712. This is a non-payment of rent for possession only, Your Honor.
Based on the defendant's failure to appear as directed by the court, default judgment shall enter in favor of plaintiff and against defendant with rent to retain possession $2,545. Just $167 in court costs for a total judgment of $2,712. Plaintiff's office to submit that judgment for entry. This is 224686 LT. This is GI&I Harbor Club versus Page Witherspoon. This matter was scheduled for 9 o'clock. It's now 10:16 by the court's clock. Defendant failed to appear for the first hearing. Based on that, court staff mailed notice for the defendant to appear in person this morning. The defendant has failed to appear as directed by this court. Based on the failure to appear, how do you wish to proceed, Mr. Morton?
Your Honor, at this time, we would ask a default judgment for possession be entered. Rents retained are $4,464.06. Court costs of $167 for a total of $4,631.06. Again, this is a possession only action for non-payment of rent.
Thank you. Based on the defendant's failure to appear as directed by this court, default judgment shall enter in favor of plaintiff and against defendant with the terms that plaintiff's office placed on the records. Plaintiff's office to submit that judgment for entry. This is 224795. Rossville Woods versus Terry and Blakely and Sarah Shiver. This matter was scheduled for 9 o'clock. It is now 10:17 a.m. by the court's clock. Defendants having failed to appear, Mr. Morton.
Actually, Ms. Shiver is present, Your Honor.
Oh, sorry.
No problem.
Oh, Ms. Shiver,
Yes.
would you turn your
Terry,
video on for me, please? Oops, sorry.
okay.
Let's try
Okay.
this again.
My hair is not done. But
No,
Terry,
I'm sorry, but I don't see the squares. Your camera's not on. I can't see you. That's all.
Okay. Terrion is here. He is in the room as of right now.
I'm sorry, Mr. Morton, have you spoken?
I did speak to Ms. Shiver, Your Honor, if I may.
Yes.
Ms. Shiver, did not appear at the first hearing because of some confusion she had. I have spoken to her about reaching out for the assistance programs, but we have agreed to a proposed consent judgment at this time. Rents retained are $4,194.20. Core costs of $198, for $4,392.20. We also did agree that there would be no order of eviction entered without a formal hearing, which would hopefully give her some additional time to be able to process through some of these assistance programs as well, Your Honor.
Ma'am, you were able to hear the comments made by the attorney just now?
Yes.
And ma'am, it's your desire to enter into a consent judgment that shows that there's $4,194.20 in rent due and owing,
Yes.
and court costs of $198.
Yes.
You understand that there will be no eviction in this matter without a full hearing?
Yes.
Ma'am, because we appear on Zoom, there is not a signed consent judgment. Have you authorized Mr. Morton to sign the consent judgment on your behalf?
Yes.
And ma'am, did he explain to you that because the complex is represented and you are not, that this judgment will not be final and enforceable for 3 days?
Yes.
Mr. Morton's office will prepare a judgment with those terms and submit it to the court for entry. Once it's signed, a copy will be mailed to you at the same address as the notice was sent, okay?
Okay.
Any questions, ma'am?
No.
Thank you so much for your patience this morning. That concludes this matter. Ma'am, you're free to go.
Thank you.
Thank you. This is 224300 LT. This is Barrington versus Metz. May I have your appearances, please?
Good morning, Your Honor. Sidney Katz on behalf of the plaintiff. Oh. There we go.
Thank you. State your name for the record, please.
Plaintiff Met.
Thank you. This case was adjourned from last week. Mr. Katz, how are we proceeding this morning?
Your Honor, this is actually a third hearing, but we did discuss this matter. We do have a consent judgment, Your Honor. There's currently a balance of $2,131, which includes costs. So it's $1,966 of rent, $165 of costs for a total of $2,131. Mr. Metz understands he has until November 7th to resolve the matter. He is trying to work with some agencies, and not Sarah, but he is hoping to have either help or pay it on his own. He was advised of MCR 4.201 and did authorize me to submit to the court with his verbal authority.
Yes.
Mr.
I'm
Metz, you're
trying.
able to hear everything. I'm sorry, go ahead.
Obviously it was turned down. Probably, I don't know what's gonna happen. We reaching out to them. They send emails back and forth to each other to touch bases of, what they're gonna do or whatnot. I don't know. I'm just getting over COVID. My first day back at work was yesterday. So I've been out for 3 weeks. So I'm gonna have basically 3 weeks of no pay. So hopefully I reach out to another agency or see what they're doing. I really don't know at this point. So I'm trying, so.
I appreciate that. Were you able to hear Mr. Katz just now regarding the resolution of this case?
Yes.
You understand that a consent judgment will enter showing that there is rent of $1,966 and $165 in court costs?
Yes.
And sir, because the Barrington is represented by an attorney and you are not, that judgment will not be final and enforceable for 3 days.
For how long?
3 business days, sir.
3 business days. He said to the 7th.
That's just the entry of the consent judgment, sir.
Oh, okay. All right.
And because you appear by Zoom, there is not a signed judgment. Have you authorized Mr. Katz to sign your name to the judgment that's submitted to the court?
Yes.
Thank you. The court will sign the judgment once it's presented by Mr. Katz's office. Mr. Metz, do you have any other questions, sir?
Not at this point.
Thank you. That concludes this matter, sir. You have a good day. Good luck to you. You're free to go.
Thank you, Your Honor, and that concludes it for me today as well. Have a good day.
You too,
Thank
sir.
you.
This is 224401 LT. This is Body versus Ely. May I have your appearances, please?
That's our date. Good morning, George of Lakeshore Legal Aid on behalf of Ms. Ely, who is present in the courtroom.
Sir, state your name for me, please.
Lakwinder Body.
Thank you. Today is the day and time set for the adjourned hearing in this matter. The parties have had the opportunity to speak. How are we proceeding this morning?
Thank you, Your Honor. We have come to a resolution of this matter in the form of a conditional dismissal. Ms. Ely has agreed to vacate the property 1 week from today, November 2nd. Mr. Bhatti has given me permission to sign his name to that conditional dismissal, so I'll be submitting that to the court this afternoon. Mr. Bhatti, did you hear the judge's speech about the 3-day rule? You have 3 days to file a motion to set the judgment, or I'm sorry, the dismissal aside, if you feel that you gave up a right that you shouldn't have, or if you were tricked or misled into this.
Okay, and then just after that,
I'm sorry, sir, who are you?
Oh, sorry, I translate for him.
That's my son, actually.
Nope, it's fine. I just need you to state your name for me, please.
Oh, yeah, this is Balkaran Bhatti.
Thank you. You were starting to say something?
Yeah, so I was just saying that after the agreed move out date, if the tenant doesn't move out, do we have to file the entire eviction process over again, or is it going to pick up from where we left off?
It'll pick up from entry of the conditional dismissal.
Okay,
No, you don't have, the short answer is no, you don't have to start again.
okay,
You have
Okay,
any
that's fine.
questions about anything else?
nope.
And
I
what
give the-
Mr. George said, is an accurate representation of what the parties have agreed to.
Yep,
That Ms. Ely will be out by November 2nd, 2022.
yep.
Yes. And there will be a conditional dismissal entered in this matter. You have to say it.
Yep.
Yes. The court will note the file will await receipt of the conditional dismissal unless there's anything else, Mr. George.
No, thank you, Your Honor.
Thank you so much for your patience this morning. Have a good day.
You as well.
Thank you all.
Thank you. Mr. Morton, did you have something else?
Your Honor, I just wanted to inquire to the court about one matter briefly, was it if I may?
Hold on one second.